I have a confession to make.
Oh,
And
go on.
honestly, I feel like this is a safe space, so I'm just going to say it. You know that moment um, when you sign up for a new app or you update your phone or maybe you open a new bank account
I have a feeling I know exactly where this is going.
and this little box pops up and it's got, I don't know, 50 pages of the tiniest text imaginable and it's just labeled terms and conditions.
Mm-hmm.
I don't read it. I never read it, not once. I just scroll furiously to the bottom, click I accept, and I silently pray that I didn't just sign away my firstborn child.
You and everyone else.
And I know I'm not alone here. But then, later on you hear these terms thrown around, HIPAA, FERPA, GDPR. It's this alphabet soup of acronyms that supposedly protect us, but I honestly couldn't tell you the difference between them.
You are definitely not alone in that. We live in this world where we are constantly clicking agree, but we rarely understand the rules of the game we're actually agreeing to. But here's the thing, and this is why we're doing this deep dive today, those acronyms. They aren't just boring legal checklists for lawyers to worry about.
They certainly sound like boring legal checklists.
They do. But if you peel back the layers, they're actually the rules of engagement for your personal life. They define the boundary between your secrets and the rest of the world. It's really about a concept that goes way back, further than the internet. It's about the right to be let alone.
The right to be let alone. I really like that phrasing. It sounds almost poetic.
It is.
So today, our mission is to cut through the jargon. We're going to tackle the alphabet soup, FERPA, HIPAA, GLBA. We're going to look at the massive cage match between the California approach and the European approach. And then we're going to take it all the way up to the big boss of privacy, the U.S. Constitution.
Exactly. We're going to see how the Fourth Amendment, written by guys with quill pens, is struggling to keep up with your Fitbit.
Okay, let's unpack this. And let's start with the ones that feel most personal to a lot of families. School and health. The source material pairs these two together a lot, FERPA and HIPAA.
Right. And people often confuse where one ends and the other begins because they both deal with sensitive personal history. Let's start with FERPA. That's the Family Educational Rights and Privacy Act.
That was old. Right.
It's actually quite old past, back in 1974.
So this predates the internet, email, pretty much everything we think of when we hear data.
Completely. And its scope is pretty broad. It applies to any public or private school that accepts federal funds, so virtually all public schools and most private universities.
And the main point is?
The core mission is simple. It gives parents and students, once they turn 18 or go to college, the right to access their education records and to ask to amend them if something's wrong.
Okay, that sounds straightforward. It's the student shield. I get to see the report card, the disciplinary records, all of it. But looking at the sources, there's a loophole here that kind of blew my mind, something called directory information.
Yes. This is where it gets fascinating and potentially frustrating.
So what is it?
While schools generally need your written consent to release your educational records, they are allowed to release what they call directory information without your specific permission, unless you actively opt out.
And when I saw the list of what counts as directory information, I had to double check I was reading it right.
It's pretty broad.
It's not just your name and address. It can include your photograph, your date of birth, your participation in sports. And get this, for athletes, it can include their weight and height.
It's surprisingly invasive for a privacy act, isn't it? The logic back in '74 is that this is stuff that generally wouldn't be considered harmful. Think about like a playbill for a school play or a football roster.
Sure, I get the football program, but we aren't in 1974 anymore. We are in the era of doxing and digital stalking. The fact that the default setting is public feels backwards.
It does. It creates a strange dynamic.
Hold on, I need to rant about this for a second. We're talking about minors here. Why on earth is the default setting public?
It's a valid question.
So if I forget to sign one slip of paper during the chaos of the first week of school, the school can legally publish my kid's home address and their weight. That seems, I don't know, dangerous.
It is a real concern in the digital age. The burden is entirely on the parent to say, stop. If you don't sign that opt-out form, the school just assumes you're okay with it.
So if you're a listener with a kid in school, maybe go check if you signed that opt-out form.
Precisely. Now let's slide over to the other big shield. IPAA, the Health Insurance Portability and Accountability Act of 1996.
This is the one everyone thinks they know. It's the most famous acronym in the bunch. You know, a boss asks why you called in sick and people scream, that's a high P violation.
And that is the biggest, most persistent misconception we need to clear up right now.
Okay, do it.
HIPAA applies to covered entities. That is a very specific legal term. It means healthcare providers, so doctors, dentists, hospitals, and health plans and clearinghouses.
Yeah.
It does not apply to your boss, your gym, or your nosy neighbor.
So let's play this out. I go to my personal trainer at the gym. I tell him, hey, go easy on me. I threw out my back. Later, he tells the whole gym I have a bad back. That's not a HIPAA violation.
No, not even close. Is it rude? Yes. Is it unprofessional? Absolutely.
Right.
But it is not a federal crime. Your gym is not a healthcare provider.
I need an analogy here because this trips everyone up.
Okay, think of a HIPAA like a magic circle drawn around the doctor's office in the insurance company.
Hmm.
Inside that circle, your data is PHI, protected health information.
Okay.
But the moment you take that information out of the circle, say you hand a doctor's note to your boss or you tell your trainer, the magic is gone.
That makes a lot of sense. Once it leaves the circle, it's just information.
Exactly. And HIPAA has two main parts that matter to us. There's the privacy rule, which is your legal right to keep your health conditions private inside that circle. And then there's the security rule, which is all about the tech stuff like encryption to keep that data safe from hackers.
And the sources mentioned an interesting overlap. If a school nurse has a record of a student's allergy, is that HIPAA or FERPA?
It's a great question. Usually if it's an education record maintained by the school, it falls under FERPA, not HIPARPA. It's a nuanced distinction, but it matters.
Okay, so we've got school and health covered. Let's talk about money. Because there is a specific law that covers our financial lives, and it has a name that sounds like a white shoe law firm. The Graham-Leach-Bliley Act, GLBA.
Yes, passed in 1999. This covers financial institutions, banks, lenders, insurance companies. And the best way to visualize GLBA is to think of a three-legged stool. It stands on three pillars to keep your money info safe.
Okay, let's walk through the pillars. What's leg number one?
First leg, the financial privacy rule. This is the reason you get those incredibly boring emails from your bank once a year about their privacy policy.
Ones I immediately delete.
The very same.
Yeah.
They are legally required to give you clear notice about what data they collect. But crucially, they have to give you a way to opt out of sharing that data with non-affiliated third parties.
Non-affiliated third parties. That sounds ominous.
It basically means random companies they want to sell your data to.
Yeah.
If your bank wants to sell your info to some marketing firm, you have the right to say no.
But again, I have to say no, right? It's an opt-out.
Correct. If you don't say anything, they can often share it.
Okay, second leg of the stool.
The safeguards rule. This is the security side. It's not enough for a bank to just promise privacy. They have to prove they are protecting it. They need a written security program, risk assessments, actual technical controls like firewalls and encryption.
So they have to walk the walk.
Hmm.
And the third leg. This is my favorite because it sounds like something from a spy novel. Pretexting.
This is the most dramatic part of the act. Pretexting is essentially social engineering.
So what is pretexting in action?
Imagine, it's 1998. I want to know how much money you have. I call your bank. I have a tiny bit of info on you, maybe your address. I call up the teller and I use a panicked voice. Oh my gosh, this is host's name. I'm traveling and I lost my wallet and I need to know if my check cleared.
And the nice teller wanting to help.
Might just give up the balance.
Yeah.
Or verify your account number. That is pretexting, creating a false scenario to get information.
That is terrifyingly easy.
It was. The GLBA made it explicitly illegal to obtain customer info under false pretenses. It forces banks to have real identity verification protocols.
So GLBA protects against the smooth talkers. Now, I want to zoom out. We've been talking about U.S. laws, which seem very specific. One law for school, one for health, one for money. It's a patchwork quilt.
It is.
But when we look globally, especially Europe, the philosophy feels totally different. We have to talk about the cage match. GDPR versus CCPA.
This is a fascinating comparison because it highlights a fundamental philosophical split. The U.S. approach is sectoral. We patch holes. Europe's approach with GDPR is comprehensive. They view privacy as a fundamental human right.
So under GDPR, companies have to ask for permission first.
Generally, yes. It's an opt-in model. You have to say, yes, you can use my data. Plus, it includes the right to erasure, the right to be forgotten.
Now, compare that to the closest thing we have in the U.S., which is California's CCPA.
Right. California is often the trendsetter. The CCPA is powerful, but it comes from a different angle. It focuses heavily on the sale of data.
And there's that visual requirement, right?
Right.
The sources mentioned, you literally have to have a link on your homepage that says, do not sell my personal information.
Exactly. But let's look at the difference in mechanism.
I think I've got an analogy for this. Tell me if this tracks. Think of it like a dinner party.
Okay, I'm listening.
Under European rules, GDPR, The host cannot put food on your plate unless you specifically ask for it. You sit down, the plate is empty, and you say, "Yes, please, I would like the data collection."
Right, opt-in.
But under the California rules, CCPA, the host starts piling food on your plate the moment you walk in the door. It's all getting dumped on there. And they only stop if you stand up and loudly shout, "Stop, do not sell my personal information."
That is a perfect way to describe it. In Europe, the door is closed until you open it. In the U.S., the door is open until you slam it shut. The burden of action is completely flipped.
That is a huge distinction.
It is, but they do overlap. Both define personal data very broadly, and both offer stronger protections for kids under 16.
Okay, so we have these laws for companies, but here is where it gets really interesting and honestly a little hazy. What about the government? What about the police? We have to talk about the big boss of privacy, the Constitution. Specifically, the Fourth Amendment.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures.
Written when papers meant a literal parchment in a drawer and effects meant your saddlebags.
Right. And for a long time, the Supreme Court focused on that physical aspect.
Yeah.
To violate your privacy, the police had to physically trespass, break down your door. If they didn't touch your stuff, no problem. But then came the telephone.
This brings us to the famous phone booth case, right? Katz versus United States.
The Katz case is pivotal. It's 1967. Charles Katz enters a public phone booth to place illegal gambling bets. The FBI knows this, so they attach a listening device to the outside of the phone booth.
Sneaky. They didn't actually go inside.
Exactly. Their argument was, hey, we didn't enter the booth, no trespass, no problem.
But the Supreme Court said no.
The Supreme Court made a pivot that changed history. They said the Fourth Amendment protects people, not places. When Katz shut that glass door, he created a temporary zone of privacy. He expected his words to stay private.
So the court ruled that he had a reasonable expectation of privacy.
Correct, and that became the new standard. It protects you against the uninvited ear, even without a physical intrusion.
Okay, so privacy isn't just about brick and mortar, it's about expectations. But then technology got even better. We got GPS and the Jones case.
U.S. v. Jones, 2012. Police put a GPS tracker on a suspect's Jeep and tracked him for 28 days. The government argued he's driving on public roads. He has no expectation of privacy in public.
Which sort of makes sense under Katz.
True, but the court pivoted back to the old school. They said, wait a minute. You physically touched his car to put the tracker on? That is a trespass. So now we have two layers of protection. Don't touch my stuff from Jones, and don't listen to my secrets from Katz.
That sounds pretty robust. But here's the problem, and the sources go deep on this. What about the third-party doctrine? This sounds like the loophole that swallows the rule.
It is the modern dilemma. The Supreme Court has historically held that if you voluntarily give your information to a third party, like a bank or a phone company, you lose your reasonable expectation of privacy. You knowingly exposed it.
Wait, hold on. I have to use a bank. I have to use a phone company. It's not really voluntary if I want to live in modern society.
That's the criticism. The doctrine comes from cases back in the 70s about bank checks. The court said you handed the check to the teller, so you can't be surprised if the teller shows it to the police.
Okay, for checks, maybe. But now apply that to a Fitbit.
Oh, wow. Yeah. A Fitbit tracks my heart rate, my steps, my sleep patterns. It creates a picture of my life that is incredibly intimate.
It creates a biometric portrait of you. But technically, you are voluntarily syncing that data to the cloud. You are giving it to a third party, the Fitbit company.
So under the third-party doctrine, have you waived your Fourth Amendment rights to your own heartbeat?
That is wild to think about. I'm just trying to get my steps in, and I'm accidentally creating a database of evidence against myself.
Potentially. And then take the Amazon Echo. It's always listening for the wake word.
The sources call this the IoT dilemma. If you bring a device into your home that is designed to listen, is it a bug that you invited in?
It complicates the Katz phone booth idea. Katz closed the door to keep the world out. We are bringing the listening devices inside the door.
So are these just business records?
That's the profound question the source material raises. If your heartbeat data and your living room conversations are just business records held by Google or Amazon, the barrier for the government to access them is much, much lower than getting a warrant to kick down your door.
This leads us to the synthesis of all this. We seem to be caught in a tension between privacy and security.
It's the central conflict. On one hand, we have laws like GLBA and HIPAA. They force companies to have security, to lock the doors, use encryption. That's good.
But on the other hand, we have privacy, our rights against intrusion. And we are voluntarily trading that away for convenience.
We are. Every time we click I accept, every time we wear a tracker, we are generating data. And under the third-party doctrine, that act of sharing potentially weakens our constitutional shield.
And we can't forget the tort laws mentioned in the sources. Intrusion upon seclusion.
Right. If a regular person hacks your webcam, that's a tort. You can sue them. It's highly offensive. But when we invite a corporation to monitor our steps, we've consented to the intrusion. We've redefined what seclusion means.
It's almost like we don't have a private sphere anymore. We just have data silos that we hope are secure.
That's a sobering way to put it. The legal system is trying to build fences around our information. But technology allows us to just throw the information over the fence because we want the cool features on the other side.
So what does this all mean for the listener? We've covered the alphabet soup, the clash of continents, and the Constitution.
It means that privacy is not one single thing. It's a patchwork quilt. Your student records have one set of rules, your bank records another, your health records a third, and your Fitbit data. That's still the Wild West.
And realizing that directory information at school is public by default, or that pretexting is why your bank asks you those annoying security questions, it all starts to make sense.
It does. It shifts your perspective from, why is this so annoying, to, oh, this is the shield.
So here is a final provocative thought to leave you with. We talked about how the law struggles with business records versus private papers. In a world of IoT devices and health trackers, we are generating business records about our own biological functions.
If the law says handing that data to a company means it's no longer private,
Yeah.
do we actually have any secrets left? Or are we just leasing our privacy from tech companies?
Something to think about the next time you strap on that smartwatch. And hey, maybe, just maybe, read the first paragraph of that privacy policy next time.
Or at least scan for the opt-out link.
Thanks for diving in with us.
See you next time.